Hi, this is Shanaz of LondonLawTutor.com. In this lecture, I'll be delivering a short introduction on the law of contract. Our focus in this lecture will be twofold. Firstly, I'll start off with introducing contracts. What is a contract? Why do we need contracts? Or what are the importance of contracts in our society? The second part of this lecture, we will look at contract formation. In particular, what are the elements needed for a contract to be valid? Okay, so let's start off defining what a contract is. So, a contract is a binding agreement creating legal obligations between two or more parties. Contracts are made and performed every moment of every day. Whether you're going to the supermarket to buy something, whether you're purchasing a train ticket to travel, whether you're entering into a new business relationship in a commercial setting, or if you're just a student and you're leasing out a property whilst you're studying. So therefore, contracts are fundamental to our legal system. They lie at the heart of our very system of laws and serve as the foundation of our entire society. Our society depends upon voluntary agreements and free exchanges in the marketplace at every level. Without contract law, these voluntary agreements would be impractical. Therefore, contract law serves to make these agreements enforceable by setting out the boundaries between them and the remedies available if an agreement or a contract is breached. Okay, so now let's move on to contract formation. There are four elements of a contract. First, an offer. Second, a valid acceptance. Third, legal intention to be bound. And finally, consideration. These will be looked at in turn. So to start off with, an offer. An offer is an indication of one party's willingness to enter into a contract with the party to whom it is addressed. The terms are set out by the person making the offer, also known as an offeror. Offers can be made to individuals as well as companies. There is, however, an important distinction to be made between an offer and an invitation to treat. Whilst an offer demonstrates an intention by an offeror to be legally bound, an invitation to treat contemplates further negotiations taking place before any contract is formed. Now, moving on to the second element, an offer always requires a valid acceptance. So, in a simple definition, an acceptance is an unequivocal, clear expression to accede to the terms mentioned in the offer. Now, this is very important. The acceptance must always correspond to the terms in the offer. If it doesn't, the offeree, the person accepting the offer, is making a new offer and is not accepting. The general proposition is that the acceptance must be notified to the offeror. However, this is subject to the postal rule. The Court of Appeal in the landmark case of Household Fire Insurance and Grant in 1879 stated that a contract is accepted once the offeree posts a properly addressed letter of acceptance to the offeror. This is when a meeting of the mind takes effect, and the law regards this as forming a contract. This applies even if the letter of acceptance never reaches the offeror. However, the postal rule does not apply to instantaneous forms of communications, where the general rule applies, which is that the acceptance has to be notified and received by the offeror. The third element of a contract is intention to be legally bound. A contract will only be formed if both parties intend their agreement to create legal relations between them. This means they intend to grant legal rights and impose legal obligations upon each of them. This intention is presumed in commercial transaction. In contrast, however, the presumption does not apply in domestic or social context unless there is clear evidence to the contrary. The final element of a contract is that it must be supported by some form of consideration. This is the price of a promise. In other words, what one party is getting in return for his promise from the other. This is usually payment. Consideration is needed at the time of the formation of the contract, and therefore past consideration is not valid consideration. Now, this brings us to the end of our four elements looking at the contract formation. We have offer, we've looked at offer, acceptance, intention to be bound, and finally consideration. Now, before we conclude this lecture, I'd like to have a look at some of the remedies available to a victim of a breach of contract. The main remedy is found in common law and is damages. The measure of damages intends to compensate the victim for the actual loss suffered by the breach of contract. so if no loss has been occasioned, only nominal damages will be awarded. There are also further remedies found in the law of equity, such as specific performance and injunctions. So this brings us to the end of this lecture. I hope this has provided you with a sound introductory knowledge and an insight into the law of contract. Thank you for listening. Bye.